For years, one question has echoed across America. Who else was connected? When thousands of pages tied to the Epstein investigation were unsealed, the public reaction was immediate and intense. Headlines moved fast, social media exploded, lists of names began circulating within hours. But beneath the noise, a deeper and more important question emerged. What does it actually mean to be named in a legal document? When the files became public, many Americans expected explosive revelations. Some believed there would be instant arrests or dramatic confirmations of long-suspected rumors. Instead, what appeared was something more complex and far less cinematic. Deposition transcripts, email references, flight logs, contact book entries, and witness statements. Inside those pages were names, some famous, some powerful, some surprising. Yet in the American legal system, context is everything. A name can appear in court records for many reasons. Someone might be mentioned in passing during testimony. They may have attended a public event. They might have been listed in a contact book, referenced in correspondence, or brought up during questioning by attorneys exploring a timeline. Legal documents often contain raw, unfiltered material gathered during investigations. They are not verdicts, they are not convictions, and they are not automatic proof of wrongdoing. But in the digital age, nuance travels much slower than a screenshot. The intensity of the public reaction in 2026 cannot be separated from the broader climate in the United States. Trust in major institutions has been fragile for years. Many Americans worry that powerful individuals operate by a different set of rules. There is a widespread belief that wealth and influence can soften consequences. So when court documents mention high-profile figures, the reaction is not just about curiosity, it is about accountability. It is about whether the system works equally for everyone. Another factor that fueled suspicion was the presence of redactions, portions of documents blacked out to protect victim identities, privacy rights, or ongoing investigative details. In the courtroom, redactions are routine. They are used to balance transparency with due process and legal protection. But outside the courtroom, blacked out text can look like secrecy. And in an environment already marked by distrust, secrecy quickly turns into speculation. Traditional media coverage tended to take a measured tone, carefully explaining that being named does not equal being charged. Journalists clarified that court filings can reference individuals without alleging criminal conduct. However, social media operates differently. Online, information spreads at extraordinary speed. Context is often stripped away. Clips are reposted without explanation. Lists of names appear without the legal framing that gives them meaning. As a result, two parallel conversations emerged, one rooted in legal standards and documentation, and another fueled by viral momentum. The American justice system relies on a specific process: investigation, evidence, charges, trial or plea, and conviction. Association alone is not enough. Suspicion alone is not enough. A person's name appearing in a document does not override the presumption of innocence. That principle is foundational. And yet, in an era of instant reaction, that principle can feel overshadowed by public emotion. Part of why this story continues to trend years later is that it represents more than a single individual. It symbolizes the intersection of wealth, influence, and power networks. It raises questions about how elite circles operate, from fundraisers and conferences to private gatherings and professional connections. Powerful people often move in overlapping environments. Business leaders, politicians, academics, and celebrities share spaces. Proximity does not automatically imply participation in crime, but it does spark public curiosity about how influence works behind the scenes. There is also a psychological component. Humans are wired to search for patterns. When multiple well-known names appear within the same set of documents, the instinct is to assume a larger hidden narrative. The mind connects dots even when the legal meaning of those connections is unclear. In high-profile investigations, documentation can be vast and complicated. It may include unverified claims, attorney arguments, and exploratory questioning. Without careful interpretation, raw information can easily be mistaken for established fact. At its core, the continuing attention around these documents reflects a deeper American conversation about transparency. How much access should the public have to legal records? How do courts protect victims while maintaining openness? How can citizens differentiate between verified evidence and unproven allegation? These questions extend far beyond any one case. They touch the foundation of democratic accountability. In 2026, transparency itself has become a cultural theme. Citizens expect openness from institutions. They demand clarity from leadership. They want reassurance that justice applies equally. The release of legal documents feeds into that demand, even when no new criminal convictions result directly from the release. The symbolic weight of disclosure matters. It signals that information once sealed is now accessible, and access in a digital democracy carries power. Yet, with access comes responsibility. Information without context can distort understanding. Responsible reporting distinguishes between mention and accusation. It separates civil litigation from criminal prosecution. It clarifies outcomes rather than implying conclusions. In an era driven by clicks and engagement, that restraint is increasingly rare, but increasingly necessary. What we know from publicly available records is limited to what those records show: references, interactions, timelines in legal arguments. We do not know what was not proven in court. We do not know guilt solely by inclusion in paperwork. The American legal system demands a higher threshold. Evidence must be tested, claims must be examined, conclusions must be reached through due process, not public assumption. The reason this story remains relevant is not because every document release brings shocking new revelations. It remains relevant because it forces a confrontation with broader questions about power and fairness. Americans want to believe that the rule of law stands above influence. They want assurance that accountability is real. And when elite names appear in complex investigations, that belief is tested. There is a fine line between curiosity and assumption. Curiosity drives investigation. It encourages oversight. It keeps institutions accountable. Assumption, however, can undermine fairness. It can blur the line between inquiry and accusation. In a country built on legal standards, that distinction matters. Ultimately, the real story is not simply about who appears in documents. It's about how a nation interprets information in the age of instant communication. It's about balancing transparency with responsibility. It's about understanding that complex legal cases rarely deliver simple narratives. The question was never only whose names are listed. The more important question is, what does being listed actually prove? In a system grounded in evidence and due process, proof requires more than proximity. It requires facts tested in court. And perhaps that's the most significant takeaway in 2026. In a world of rapid headlines and viral posts, the truth is often quieter than the reaction. It's layered, procedural, and sometimes unsatisfactory, but it's built on standards designed to protect fairness for everyone.